Any mention?
Yes.
Please, Lordship. This item number 9, Lordship. I have taken the concern from the government also.
9, huh?
Lordship. Item number 9.
My lord, I'm for the state respondents.
Fernandez.
Yes. So I will let the matter may come to the Lordship after 2 weeks, Lordship.
My lord, no objection, my lord.
It's the request. 8 or 9? 9.
9, my lord.
9, my lord.
The request of the petitioner. This is matter for 2 weeks. Yes.
This similar prayer, Lordship, for item number 10, 11, 14 and 15, my lord.
My lord, I'm in number 10 and 11 for the state respondents.
Number 14, I'm there for the respondent, my lord.
There is no objection.
No, lordship.
No objection, Lordship. Interim may be extended, Lordship. In item number 11, there is an interim.
There is an interim order.
11, my lord.
Yes, Lordship.
Petitioner in item number 10, my lord.
Mr. Sangma is for the private respondent, my lord. In 10
Item
and
10,
11.
there is no interim order.
Yes, interim, my lord.
Item 11 also there is interim order.
Lordship.
10 and 11 are connected, Lordship. In both the matters, there is an interim order.
Let's continue, Lordship.
Okay. Let's see on the prayer of Mr. P.T. Sangma, London Council, appearing for
The petitioner, my lord.
Time for the respondent.
Private
the
respondent.
respondent. Wait.
Yes.
Okay. List this matter after
After 2 weeks, Lordship.
the interim order passed earlier. Continue and return about it.
Obliged, Lordship.
14 and 15 also, my lord. 14 and 15.
14 and 15 also same matter.
No different matter. Because
Your lordship, for item number 15, I'm appearing for the respondent, your lordship.
this is all respondent.
For respondent, your lordship.
The 14, 15 they are connected.
They're not connected, lordship. 14, I'm appearing on behalf of the state, lordship.
These are all quashing matters.
Lordship.
Any objection? No objection.
No, lordship.
This also. At the request of list of petitions. 14, 15. Yes.
Much obliged, lordship.
Deeply obliged, my lord.
Please, Your Lordship, I beg to mention item number 17.
Oh, 17.
Sorry,
Wait first.
Yes.
17.
17. I'm appearing for the private respondent, Your Lordship.
And for the state, my lord.
Yes. Mr. General, you are there.
Your Lordship, I pray for 2 weeks' time due to personal difficulty of the arguing counsel.
The personal difficulty is
These are new matters, 2024 matters.
1 week, next week.
What is the use if it is not taken up after 1 week? Then again it will be trouble for you. You have to come again.
As your lordship wish.
Yes, sir. And the request of state, who is
My
there?
lord, no objection.
So after 2 weeks of the request made in waiver, respond number 7. Yes.
Right, Your Lordship.
May it please, Your Lordship. Item number 18, Your Lordship.
Yes.
Let it be listed by next week, Your Lordship, with your permission.
Criminal
Not, by next week, Your Lordship, with your permission.
after a week at the request made on behalf of the appellate. Yes.
Highly obliged.
Your Lordship, I beg to mention item number 16, my lord. I'm praying for, my lord, a week's time, my lord. A week's accommodation, my lord.
No objection, lordship.
This also after a week at the request. Yes.
Deeply obliged, Your Lordship.
Much obliged, lordship.
I beg to mention, my lord, hearing number 4, 7, and 13. If lordship will competently and take up next week, subject to lordship convenient. I'm for the petitioner, my lord.
Item 4.
For item number 4 and 13 for the petitioner, and number 7 is for the respondent.
Inta.
Too many
13
occasions.
for the petitioner.
Too many occasions.
It is earlier lordship has taken up the matter hearing number 4, and it was deferred again.
I was requesting
was
my
deferred
colleague
again.
that today may be my last day to argue this case. Because I put the papers.
But then who knows? You may come back again.
By the way,
Who knows? You
that
may
is
come back
why.
again. Nobody knows.
No, I have requested because of my health.
That is a convention. That is a convention. You do it, and then who knows?
Yeah.
There may be a very lucrative offer also for you.
Next
Anyway.
week, subject to lordship convenient.
See,
Yeah, next
every day is convenient for this court. So whenever you feel it all right, we are ready.
Okay, next
Any-
week, Your Lordship. Let it come next week.
So item 4.
4, 7 and 13.
4 and 7 are this council matter. 13 is the
Anyway,
state
4,
matter.
4 you just say respected by the Learned Senior Counsel for the petitioner and not objected to by
This one also.
Learned Counsel acting for the respondents. This is matter after 2 weeks. Yes, and then what else?
Number 13 is, my lord, in fact, a similar issue is pending
Yes,
before division bench.
7 is also 7.
7
you are
also
there,
I'm
7
making
also
mention.
taken time.
Council matter.
Yes.
District Council.
You are also there.
I'm there for the private respondents in 4 and 7.
In all the matters. So there also same order. 7 also same order. Then 13.
13, my lord, see, the issue is pending for the division bench. So we pray for 3 weeks adjournment.
What is the issue involved there?
My lord, the issue involved where lordship has referred one point legal issue to the division bench.
Okay. That is a POXO matter.
POXO matter.
Okay, it is submitted by the Learned Counsel appearing with the parties. That a similar issue, the issue raised. It's a similar issue. Similar issue is pending before division bench for adjudication. And we stop. A prayer has been made. Yes, a prayer has been made to adjourn the matter till the disposal of the matter before the division bench. Prayer allowed at least after 3 weeks.
Please, Your Lordship. My Lord, I beg to make a mention of item number 8 on behalf of Mr. H. Karmalang, my Lord. My Lord, can you have the matter after 2 weeks?
Oh, Mr. Kharwanlang,
Lordship,
he is not in a mood to do any hearing now.
seek some accommodation, my Lord.
When he will be ready? For how long? Yes. Any objection? No
objection, Your Lordship.
Yes, sir. The request made on the behalf of the state respondents. This is matter after
2 weeks, my Lord.
that will be enough for him.
Lordship.
But this case is
Deeply obliged.
Yes.
Please, Lordship, I beg to mention item
You have
number
not
6.
finished. Yes.
Item number 6, Lordship. Lordship, it's a joint mention. Two weeks time, Lordship may be given. This matter.
Yes.
It's a joint mention.
Joint request. At the joint request made by the parties, this is matter after 2 weeks. Yes.
Obliged, Lordship.
Lord, item number 3, my lord, I'm making a mention on behalf of Mr. James. Thank you, my lord. I've been requested to seek time in this matter, my lord, only for a day. Due to some personal difficulty, he is unable to come, it seems, my lord, today. He put in a request to me to make a mention on his behalf.
Yes, at the request made by Mr. Thapa. The request made by Mr. Thapa on behalf of Mr.
James, thank you.
Thank you. Learned Counsel for appearing with the petitioner. The matter stands urgent for one week.
Let
Not
it be
tomorrow.
2 weeks.
Tomorrow
my
is
lord.
not possible. We will not have
2 weeks, my lord.
matter stand yes urgent for 1 week.
Available.
Yes.
Supplementary cause list, item number 1.
Yes, Mr. Devnar.
Lordship, here in this case, I filed this petition on behalf of the Union of India regarding matters of this, Your Lordship.
This is a criminal petition.
Criminal petition, Your
Filed
Lordship.
by Union of India.
Yes, Your Lordship.
Yes. What is the
The
matter?
matters here, you will see here on 15 and to 16, there was function of the Cherry Blossom Festival. And in this festival, what's happened on 15, incidentally, some incident happened among the army members. Army members from the Assam Rifle as well as the army. This person got to know what? Some incident. So subsequently what's happened on 16, this matter is reported from the army to DGR. That incidentally has happened, and then some persons can be such and such was involved in this case. Then subsequently what's happened on 21st, the DGR referred the matter to the Eastern Air Command to take appropriate actions. So accordingly, proceeding was started and it is going ahead. In the meantime, on 14 December, the respondent number 3 here, Major Binay Kumar, he has filed one zero FIR in this here in Dilbang police stations. Then zero FIR has been registered and sent it to the Rigo district. So on the basis of this zero FIR, whatsoever got from this Rigo district, and they have registered the case on 3rd January 2025. So in this case, Your Lordship, already proceeding was started in the Army Act, and they have earlier and subsequent finally this order has come 14 January 2025. So in this instance matter, both the parties are belongs to army and army officials. So when this army has taken this matters and civil consequences there, if any, it is not necessary, civil authority, if even they register, then it will be taken by the army only. So it will be unnecessary exercise. Already the proceeding was in motion, and this convening order is there in Annexure 6, page 46.
Page 46, yes.
So this is the convening order. May I read you, Lucy?
Oh, this has happened at Cherry Blossom Festival.
Yes.
Why, there was too much enjoyment on the
Yes.
part of the...
Yes. Then also the army people is involved. So they are having such different areas. So here, you see, we have before this honorable court, this is the it is given. This is a copy of the fresh convening order. There is such and such in alleged incidents that took place this midnight of 15 November 2014, Cherry Blossom Festival, such and such report comes modern Calcula, Bhoi Nimbong, Shillong, outside the premises of military station is flowed herewith for necessary actions that you want please, and this is the convening order. So when this and subsequently convening order as a whole it is given.
Who filed the FIR?
FIR filed with the private respondent number 3.
Where is the FIR?
Copy of the FIR is annexure 3. Annexure 3, page 34.
Page 34.
Yes.
What is this? Page 28.
Page 28, you will see this is the
report.
This is the report, you will see. This is the report what's happening on 15. This has been reported to the DGI.
Yes. This FIR has been lodged after much delay, isn't it?
Yes, you will see.
The incident took place in the month of November. 15 November 2024.
Yes. And 16 November it has been reported.
14 December it was filed.
So it will see immediately on 16 December 28, this is the information given to the authority of DGR. This one person involved in this matter was the mentioned. So you will see subsequently in page 31, this is the Director General Assam Rifle. He has written to the headquarters Eastern Command reporting and request for injunctions assault on officers.
So FIR is against some individual. How Union of India is petitioner here?
So here officer of the Union of India.
How can it be? How?
They are in official duty.
Official duty in Cherry Blossom Festival. Some criminal activities take place. Whether Union of India's instruction was there to do that? Whether Union of India will
They are,
take
they
the
are
liability.
going to allocate
Yes,
them.
madam. Just tell us how can this? What is your thing? You're just what is the? You have any instruction in the matter?
No, Lordship. I've just received
Whether
the file.
the case has been registered or not.
Lordship,
Getting registered, Your Lordship.
we'll have to seek instructions, Lordship.
No,
but
but
at the same time, whether Union of India
this
has
FIR,
locus.
paragraph 14. If you come to page 38,
Lordship.
you'll find at paragraph 14, some individuals are named there,
Lordship.
and it seems that there are some sort of like fighting or kind of a physical tussle between
Lordship.
the officers of
Lordship.
army involving the complainant and this.
Lordship.
Now, once the complaint has been filed against some individuals, maybe army officers, how Union of India comes?
Lordship. What was the role that was played out
show
over
us-
there at the venue, Lordship?
You show us how Union of India comes here. Which way Union of India is affected here?
The officer of the Union of India has.
No. Then officers in Union of India, there the other side also is officer of the Union of India. Are you disowning the complainant is not your officer? Then how Union of India comes? Was it a criminal act on behalf of the Union of India?
So Your
You show us how a criminal quashing application will be maintainable by the Union of India in this kind of cases where the persons have been specifically named. The incident took place in some area outside army area. FIR has been lost to the state police. Which Union of India comes here? How Ministry of Defense gets involved here? Ministry of Defense is not at all an accused here.
Here, Your Lordship, yes, because this the Union already has
These
taken.
officers were definitely not acting in their official capacity when they were attending those functions. How Union of India is coming here? You satisfy us about your locus standi. What is the section of law here? This is under
109.
it is BNS.
BNS, Lordship.
Well, you have to tell me what those things is.
Lordship.
109, 117, 126.
What was it speaks of? What is 109?
109 is
Attempt to murder, Lordship. That's why the locus is questionable here.
Satisfy us on locus. Give us some decision to show your locus.
So let's see the record is this. Then I need some time.
Definitely. When do you want it?
Then maybe the next week then.
Say this is an application seeking quashing of FIR dated. FIR
3rd of
number
January 2025,
3rd
Lordship.
January.
FIR number 2 of 2025, dated 3rd January 2025, filed by the respondent number 3 against some officers working on the petitioner. Against some officers of Union of India named in the FIR. Name in the FIR. Stop. The allegation made in the FIR indicates that there was involvement of the accused in their personal capacity. Stop. The present application has been filed by the Union of India, represented by the Secretary to the Government of India, Ministry of Defence. Stop. Since the criminal action concerns the perpetrator in his individual capacity, it prima facie appears that the petitioner does not have any locus standi to file this application. Stop. Mr. R. Devnath, just however, Mr. R. Devnath and CGC maintains that the Union of India can maintain, can file the application seeking quashing of the FIR where many of its officers are involved. Stop. The Learning Council has sought for grant of some time to place relevant law in this regard before this court. Stop. Prayer allowed. This is met after next week, after a week. Tell you what, you see, Mr. Devnath, there is a huge doubt in this kind of cases you will come out with any law. Otherwise, you may do it in a different way, but the Union of India cannot be petitioned. That is what the Prime Minister view.
Yes, because officers are involved.
Anyway, if you want that Prime Officer view, which we have recorded here, that you have no locus standi, you can alter it, maybe write it in a different way. But then you will have to satisfy us on the next your locus. How Union of India gets involved here? Madam, you also take instruction.
Lordship.
See the progress of your investigation also.
My lord. Much obliged, Lordship.
Daily cost list, item number 1.
Yes, please.
May it please your Lordship.
Yes.
My Lord, this application is filed under Article 227 of the Constitution of India. But I am told that your Lordship is sitting in the appellate divisions of the Commercial Courts Act. My Lord, a dispute of commercial dispute arose. My Lord, this is the 4th case we are following the defendant. The first case was filed by us as a plaintiff before a court in Assam at Hatsingmari. Then the second suit was filed by the respondent herein.
One thing, you said that this court is sitting as
commercial appellate.
Is it?
I am told, I am not very sure. Commercial Courts Act, I think your Lordship is the import appellate.
This court doesn't know much
but
about
even
this.
then, my Lord,
No, whether this court has been sitting as
commercial division bench, your Lordship is part of the commercial division.
So this is
no, my Lord, let me place it, then your Lordship. My Lord, what has happened? If your Lordship looks into the Commercial Courts Act, my Lord, first.
yes.
Now, if your Lordship looks at section 2.
No, but your revision here is under 227.
227.
So can confine it to that.
Yes.
You have challenging what order?
Yes.
Why commercial court is coming here?
Because the dispute is a commercial court.
But
the Tura court is the Tura court which took up the matter is not an empowered court under the Commercial Courts Act, because we are taking the point of jurisdiction. Because now after the Commercial Courts Act, a commercial.
You raised that question before that court.
Yes, my Lord. They are adjourning it at the injunction.
Have you raised that thing?
Yes, my Lord.
Where is that your petition?
My Lord, that we have raised it subsequently after filing of this petition, my Lord.
Then
but even then, your Lordship will look into the order passed by the impugn order.
See, once you have filed an application, your primary ground of challenge is jurisdiction, and since you have already filed an application challenging the jurisdiction of the court there, you get 227. Why 227 comes here?
Because, my Lord, of the order which is put under challenge, because that court is not the empowered one, number one. No, but second is,
see,
my Lord.
Once you have raised maintainability there and you have the option of doing so, Why 227 being exercised? 227 will come only in exceptional situation.
I'll show your lordship. I'll try to satisfy your lordship the exceptional circumstances.
So, but then how can you expect that this court and that Tura trial court also will exercise the same jurisdiction concurrently?
No.
Once you have
your
filed
lordship will exercise only the supervisory jurisdiction under 227.
See, Mr. Try to understand.
Yes, madam.
You are questioning the jurisdiction of the court.
As well as the legality of the order.
It's all right. If court doesn't have jurisdiction, this order will be illegal, definitely.
Yes, madam.
So this definitely strikes at the root.
Yes, madam.
Isn't it?
Yes, madam.
Now, your submission is that subsequent to the filing of this application, you have already filed an application.
Because since there is no stay order and we have to file the WS and all this application within the time.
So you just pursue it there.
No, my lord, only thing is that we have filed it and your lordship knows that if
once we pass any
yes.
order at this stage now,
yes,
then your petition there will be rendered infraction.
No, your lordship will kindly appreciate one thing. Once an order, ex parte injunction order is passed under Order 39 Rule 1 and 2, then we go for vacation of that order or modification of that order. That injunction application has to be disposed of it within 30 days. We have approached the court has fixed the matter next on April.
When did you file an application for seeking vacation of the ex parte interim order?
18th of February.
That means 18th, and when did you prefer this application?
No, earlier.
18th of February means 18th of February, so 30 days from 18th of February is what date?
18th of March.
So what date there we are now?
They have fixed it in April and they have obtained an ex parte.
No, you go file an application, show that the provision there.
So your lord,
27, that situation has not arisen at this
your lordship, without expressing any observation on the merits of the case, your lordship will at least direct the trial court or which is
Where is the order? Which is the order which you are
yes,
challenging?
Just a moment. Just a moment. The order is at page 365.
This ex parte injunction order.
Yes, madam.
Otherwise applicable under Order 43 Rule 1R.
My lord, since we have raised the point of jurisdiction, my lord, and this is an order which the court doesn't have the
jurisdiction. Go by the provision of CPC, the question of jurisdiction has to be raised before the.
No, it can be raised at any point of time before any forum, my lord.
See, if there is inherent lack of jurisdiction.
Yes,
but then say there are other aspects.
No, so we'll not bother your lordship that if your lordship at this stage doesn't want to interfere, but at least your lordship will direct the trial court to dispose of this application within a period of 30 days because we have filed the application as well as we have filed an application for taking the point of jurisdiction and also another application for rejection of the plaint because that court is not an empowered court under the commercial.
Application for seeking stay, vacation of this thing stay?
Yes, it is that.
This is not appended here. So everything you have done after filing.
No, we have filed a separate miss case along with this case.
Along with this case?
Yes.
No. Where is your application before the trial court seeking vacation of the ex parte interim order?
Well, that has done subsequently after filing of this, so we have not brought it on record. But your lordship, we can produce it before it. But your lordship will take my.
No, that is not at all required. You see, 227, this court will exercise. We do not know the other aspects. Only in exceptional cases. 227 is not an alternative to the procedure prescribed.
I appreciate, my lord. I appreciate, my lord. Your lord,
227 cannot be exercised on mere asking.
Your lordship is absolutely right. Why we came before you on this? Because this will set things in right, not only in the court in Tura, but all over the courts in Meghalaya. Because, my lord, after the Commercial Courts Act, my lord, any commercial dispute has to be registered as a commercial suit. But here, what has been done, they have registered as a title suit. And why they have filed it as a title suit?
Why don't you raise all those?
We have raised it, my lord. We have raised it, my lord. That's why I pray, my lord. All the applications that the application we have filed for vacation of the interim order on last date on 18/2, your lordship will only direct it to dispose of it within a period of 30 days from the date of filing.
But then this court doesn't know when you have filed this application.
My lord, 18/3, my lord. Your lordship will record my submission that it was filed on 18/3. I have that copy of the application. I can show it to your lordship.
That is not needed.
Yes.
See, you are senior counsel speaking here. We take your statement as
yes. That's why your lordship will record my statement.
That is your standing before this court.
Yes. I have filed not only an application for vacation of the interim order. I have filed an application under section 10 because due to multiplicity of proceedings, because he is moving one court of the another. One court is vacating the order under section 10. He goes and file it in a different court. This is the fourth suit he has filed in Tura under the same subject matter. So we have asked the concerned court to return the plane because that has not been registered as a commercial.
So here
suit.
section 10 also will come, isn't it?
Yes, yes, yes. Section
So
10.
you have not filed any application under section 10.
In this before this court, my lord, under 227 we have played under section 10.
Section 10 also you have to raise it there. You cannot
We have
raise
raised
it
it.
to
We have
227.
we have said that to stay the proceeding by invoking section 10 by this honorable court, but in the
Question
court
of section 10 has to be raised before the trial court.
we have raised it, my lord. We have raised it.
Not in a revisional court for the
Yes, yes, my lord. We have raised that section 10, then for vacation of the interim order, and another application we have filed for return of the plane because it has ought to be registered as a commercial suit. I don't know, my lord, whether your lordship may be better aware, my lord. I don't know whether in Meghalaya the courts below have been empowered as a commercial courts or not. My lord, I could not locate the notification in the website of the Meghalaya High Court.
See, this question should not ask the court.
Oh,
You
yes,
can ask any other legal
Yes,
experts. They can guide you.
My lord, I'm planning to contact the Registrar General because I don't know because this case is registered as a title suit.
Anyway, we'll just
Yes,
hard. Mr. Patawari.
BD Kunwar.
BD Kunwar.
Bhaskar Dev Kunwar. Assisted by my friend, man.
Yes. Not a senior counsel assisted by so. Stop. By this application under Article 227 of the Constitution of India, the petitioner has challenged the ex parte interim order dated 13/11/2024, passed in Miss Case number 23 of 2024, arising out of title suit number
8 of 2024
by the Additional Deputy Commissioner Thura. Stop. The learner give a paragraph. The learner senior counsel submits
Move application of yes, not correct file application.
report of Additional Deputy Commissioner without any jurisdiction has passed the impine order further submits that there are other litigation pending between the parties involved hearing in other part of the country, in courts outside the state of Meghalaya, in courts outside the state of Meghalaya. Concerning the issue involved in title suit number so and so
8 of 2024.
It is a submission of the senior counsel that the learned trial court would not have entertained the title suit number so and so, and as a consequence, the order dated 13/11/2024 is without any jurisdiction. Paragraph, it appears from the material of record that impine order dated 13/11/2024 is only an ex parte order of injunction What when this date was next date was fixed on 9/12/2024. What
After
happened?
that, my lord, we first date we missed it. Then on 18/2 we filed 3 applications. One we filed for vacation of this ex parte interim order.
So this interim order is still continuing.
Yes. So we filed an application for vacation, then section 10 and another for rejection of claim.
Which was passed without any without issuing any notice, which was issued prior to issuance of notice to the petitioner hearing. Stop on the query made by the report by this court, the London Central Council submits that the petitioner hearing has already. You filed your written statement.
I have filed my written statement.
Written statement before the trial court, as well as an application seeking vacation of the
Ex parte interim order, and
Ex parte
also section 10 application, and one for rejection of the plain.
That's what you said on the query made by this sir. Written statement as well as an application seeking vacation of ex parte interim order dated 13/11/2024. That apart, the petitioner has also filed an application under section 10 CPC questioning the maintainability of the suit before the trial court. Clear paragraph. Since the petitioner has already filed his response before the trial court, this court does not see any reason at this stage to entertain this application under the distribution application by invoking jurisdiction under Article 227 of India. Stop. And hence the same is dismissed.
Well, your lordship will dispose of it, or because dismissed they will interpret it, because then your lordship will kindly indicate that without expressing anything on the merit they will take it.
Same is dismissed without expressing any opinion as to the merit of the matter. Stop. The trial court, the London trial court. This is however, do not say before London, before trial court, just say, however, the petitioner will be at liberty to raise all the grounds. Petitioner will be at liberty to agitate all the grounds raised herein before the trial court. Raised here in this petition before the trial court. Stop. The London trial court shall make an endeavor to dispose the objection raised by the petitioner within a period of 30 days from the date of receipt of a certified copy of this order.
Yes. Because that's the mandate of the law under Order 39 Rule. My lord, we have filed also another application. Your lordship will kindly record it, because we have also filed another application under Order 7 Rule 10 CPC for rejection of the return of the claim. Return of the claim.
Anyway, there you see, which said where we said that petitioner has also filed an application under section 10 CPC questioning the matter of the court, as well as under Order 7
Rule 10.
Rule 10.
Yes, for return of the claim CPC. We are obliged, madam.
If there is anything missing, that will be corrected.
Yes, madam. Well, this order will go a long way, because we had tried our best before that concerned court. This is that we are not empowered, but since the case has been filed as a title suit, we are helpless.
See, the problem here is that you see, The 227,
yes, yes,
as far as this course is,
I know my limitations.
basically has become a regular course here.
Yes, ma'am.
See, it is entertained without even realizing when it can be.
Yes,
now, we do not want to replace the regular provision of law by 227.
Well, and Commercial Courts Act, there is a specific provision for appeal. We don't even have to go for Order 41 Rule 1R now. Because Commercial Court, it has to be expeditious.
Yes. No, but then since here the exercise of this thing, jurisdiction is under CPC. Presumably, see whether that has been filed as a commercial suit or not, that we do not know. You take a plea.
Yeah, we have taken.
That it cannot be considered as a regular suit. It has to be a commercial.
Because in the
So that is why.
because in the commercial suit, my lord, with utmost respect, there is a provision under Section 12A where there is premediation is there. Now to avoid premediation, they register it. They file a title suit, so that that compulsory premediation will. They can avoid it.
That bar will not apply.
Yes,
to overcome that bar.
Yes, but it will otherwise go on Section 10 because on the same subject matter, this party is moving 4 courts in 3 in Assam and 1 in Tura. We are obliged for, my lord. It was a pleasure appearing.
Item number 2.
Lordship, the connecting counsel SK Nongrum is on sanction leave due to personal difficulties. I pray for one week's time, Lordship.
What is the matter?
Well, this is a refusal of the initially by the trial court. I have filed a title suit before the trial court in this council, my lord. I filed an application for the respondent herein was initially the owner of the land and house, my lord. That was sold to me subsequently. So I have given them notice to vacate the land, and in her refusal to do so, I have filed a suit before the trial court, and along with an application
for eviction, suit for eviction.
Eviction, as well as for deposit of rent, my lord, because she has already sold the property to me, my lord. So that was refused by the trial court as well as the lower appellate court, my lord. Both my applications, my lord.
So you have
That's
come
why
against, concurrent finding.
Well, it's a registered sale deed, my
You
lord.
are in a very difficult situation.
I understand, but my lord, one thing is that the sale is a registered sale deed, my lord. That is not disputed, my lord. Records has come, my lord. Trial court has come. The matter can be fixed for hearing, my lord.
Yes, definitely, Mister. Please give your name.
Adjutant.
Mr. So-and-so, Learned Counsel, appearing on behalf of MS SK Nagrum, Learned Counsel for the respondent, prays for an urgent matter on the ground of non-availability of the arguing counsel. Mr. L. Karim, Learned Counsel, appearing for the petitioner, has no objection. Prayer allowed, this chapter, 2 weeks. Obliged.
Most polite.
Hearing item number 5.
Lordship, in this case, I was supposed to produce a record to show whether the bank has complied with the guidelines issued by the Reserve Bank of India, but till date I have not been successful in getting that because the head office is out of.
This court has forgotten everything.
So, Your Lordship,
Malad can have the order dated 19/8.
Order dated 19/8. 2024.
Yes, Your Lordship. In the course of hearing, Your Lordship had asked me to produce a record if the guidelines had been complied by the.
Okay, the record, you were awaiting record.
Yes.
You are asking for some more time.
I may be allowed one more time, Your Lordship. I'll send them another strong letter in.
Sorry, there is no objection by the.
Yeah, because they will have no objection. Now, see, Mr. Paul is also on board.
By order dated 19/8/2024. records of proceedings of the petitioner. Records of proceeding involving the petitioner pertaining to this case was called for from the respondent bank. Stop. MST Youngie, Learned Senior Counsel, appearing for the bank, submits that due to certain difficulty, the records could not be obtained from the bank and prayed for grant of some more time. Mr. Thapa, Learned Counsel, appearing for the petitioner, has no objection. So prayer allowed. Further 2 weeks time is granted, or more, 2 weeks.
3 weeks time.
3 weeks time is granted to the respondent bank to produce the related record before this court. District court.
Item number 12. Item number 19. Item number 20.
Yes.
Please, Your Worship, this is an application under 482 for quashing on the basis that the parties in the case have arrived at a settlement.
Yes. What is the offence involved here?
Your Worship, 279-304A, rash and negligent driving and causing death by negligence.
304A.
Yes, Lordship. Causing death by negligence, Your Lordship.
Can a
Lordship, there are certain judgment of this honourable court itself, Your Lordship.
304A?
Yes, Your Lordship.
Very serious.
Not by this court, but by some other judge.
See, 304A means somebody
was killed. Died.
How can compromise be entertained?
The person who has lost his life is not a party to the compromise.
Definitely.
Your Lordship, the parents of the deceased are
That can also not be
parties to the compromise.
Nobody has the right to do that on behalf of that person.
I have got the judgment which says that 304A.
Who is appearing for the any private respondent?
Yes. Private respondents there.
It is compromised. And how? How?
Lordship, primarily outside of court, you said that.
Now, how can it be compromised?
Lordship, basically,
you don't have any authority to compromise.
Victim is not a party.
You show us the law that you have a authority to compromise.
Criminal trial is proceedings, but prior to commencement of trial, since they approached us, we said yes.
No, but then death took place before, isn't it?
Correct.
Yes.
So how can you entertain? How can you enter? I think there is some law, madam, probably by the apex court or maybe.
Yes, Your Lordship. It says that
The,
304 is a
the
heinous
judgment
crime.
of Lakshmi Narayan and Narendra Singh are two Supreme Court judgments which deals with quashing, and it cannot be quashed only if there's
that we know, this thing,
Gyan
Gyan
Singh
Gyan
is
Singh
the-
judgment and all
yes.
those
Yes,
things.
is
There is no question about this court power under 482. But then in an offence involving 304A, that is what the difficulty is.
because this has an impact on the society, Your Lordship. It is
Your
serious
Lordship,
and a heinous
there's
crime.
a specific
And-
distinction in Lakshmi Narayan what impacts the society, and this case does not cover under Lakshmi Narayan. It specifically stated that.
Sends a wrong
I'll make, if
signal.
may please the judgment, Your Lordship.
Please, sure.
Lordship, may I have para 29.2 and 29.3 of this judgment.
Which judgment? This Narendra Singh.
Yes, Your Lordship. 29.2 and 29.3 is important.
Which is this thing? Citation.
Yes.
29.2 talks about which matters can be exercised under 482. If I may just read, Your Lordship.
Yes, please.
When the parties have reached a settlement on that basis, petition for quashing of the criminal proceeding is filed. The guiding factor in such cases would be ends of justice or to prevent abuse process of any court. While exercising the power of the High Court is to form an opinion of either of said two objectives. 29.3, Your Lordship, is more important. Such a power is not to be exercised in those prosecutions which involves heinous and serious offences of mental depravity or offences like murder, rape, dacoity, etc. Such offences are not private in nature and have been a serious impact on society. Similarly, for the offence of so and so and so and so. Your Lordship, these are specifically stated that these are not offences of private nature.
See, that is
Specifically
something.
stated. On the basis of this judgment, Your Lordship, this Honourable Court itself has passed two similar judgment in two similar cases, similar facts and circumstances. If I may just please. First, I'll please this.
This court has passed, hasn't it?
Your Lordship, Justice W.
Coordinate
Dingdor.
bench.
Alternate.
This is also 304A.
Yes, Your Lordship. The facts and circumstances are exactly and identical, Your Lordship.
You give the prosecution copy of those.
Just please listen.
Madam, please see whether this judgment will cover you or not. And if you have something, then this is something.
2000. This one, this judgment which I have just placed before Your Lordship, it has referred to the Supreme Court judgment of the year 2015 at para 9, Your Lordship. It says that even in these matters where accidents have taken.
Anyway, just we'll come to your thing first. Just let us deal
Okay,
with
Your
these
Lordship.
things. Yes, dear, which you are referring? This is criminal petition 34.
Yes, Lordship. Not 34, Your Lordship. The other one.
Criminal petition 11.
11.
2011. Which part will be relevant?
I have only one copy. Para 11 onwards, Your Lordship. On consideration of the submissions made by so and so, the fact that the motor vehicle accident has taken place leading to the lodgement of the FIR and the consequent proceeding before the Court of the Judicial Magistrates class is not denied. The fact that the parties involved have also arrived at a compromise leading to the execution of a said compromise deed is also not denied. The only consideration before this court is whether allowing the proceeding to continue would be the ends of justice or discontinuing of the same would prevent the abuse of process of court. Logically speaking, since the complainant and the accused have arrived at a compromise, it would be a futile exercise for the court to continue with the proceedings, considering the fact that offences involved are not heinous in nature. On proper consideration, under the facts circumstances of this case, this court has come to the conclusion that the petitioner has made out a case for putting a halt to the proceedings, GR case number 123A. Now, para 3 of this judgment clearly states which sections were involved, Your Lordship. 279, 338, 427 and 304A of IPC.
So facts and situation are identical.
Exactly identical, Your Lordship. The pillion rider sitting behind the accused person had expired on the basis of an accident which occurred. Another one is the criminal petition number 34,021 also, Your Lordship. Yes.
They are also same offence.
Same offence, Your Lordship. 304 is involved. In this decision, Your Lordship, the interesting and the case of Lakshmi Narayan was considered prior to quashing the proceedings before the third magistrate.
But these judgments, though, have this thing quashed those cases, they have not specifically discussed that issue, that whether there can be a compromise on behalf of a dead man. It's basically gone by the fact, the proposition of law which was laid down in another.
That's why, Your Lordship, in this
or that
settlement, it's not only the complainant that has entered with the accused person, but even the parents of the deceased person have also entered into the compromise.
We can understand. The question is that, you see, even the right of parent also in such a situation is what is something to be missing. What is the decision you have rendered, madam? This that 2016 SCC. This is a Kerala.
This is Kerala, Your Lordship, but while passing this
Kerala will not be binding. Rather, the ordinary decision of this court will be binding.
Will be binding. But Your Lordship, while rendering this judgment, Your Lordship,
yes,
the Kerala High Court has relied on the State of Punjab versus Saurabh Bakshi at Para 9, Your Lordship. SCC 215-5182.
You have that decision with you?
You have this? That I have not got it.
State of Punjab versus Saurabh Bakshi?
Yes, Your Lordship. But they have reproduced the relevant portion, Your Lordship. This court has been constantly noticing the increase in number of road accidents and has also noticed how the vehicle drivers have been totally rash and negligent. It seems to us driving in drunken state in a rash and negligent manner, or driving with youthful adventurous enthusiasm, as if there are no traffic rules or no discipline of law, has come to the center stage. The protagonists, as we perceive, have lost all respect for law. A man with the means has, in possibility, graduated himself to harbor the idea that he can escape from the substantive sentence by payment of compensation. Neither the law nor the court that implements the law should ever get oblivious of the fact that in such accidents, precious lives are lost, or the victims who survive are crippled for life, which in a way worse than death. Such developing of notions is a dangerous phenomenon in an orderly society. Young age cannot be a plea to be accepted in all circumstances. Life to the poor or the impecunious is as worth living for us as it is to the rich and the luxuriously temperamental. Needless to say, the principle of sentencing recognizes the corrective measures, but there are occasions when the deterrence is an imperative necessity depending upon the facts of the case. In our opinion, it is a fit case where we are constrained to say that the High Court has been swayed away by the passion of mercy in applying the principle that payment of compensation is a factor for reduction of sentence to 24 days. It is absolutely in the realm of misplaced sympathy. It is, in a way, mockery of justice. Because justice is the crowning glory, the sovereign mistress and queen of virtue, as Cicero had said, such a crime blights not only the lives of the victims, but of many others around them. It ultimately shatters the faith of the public in judicial system. In our view, the sentence of 1 year as imposed by the trial magistrate, which has been affirmed by the appellate court, should be reduced to 6 months. Before parting with the case, we are compelled to observe that India has a disreputable record of road accidents. There is a nonchalant attitude among the drivers. They feel that they are the emperors of all the survey. Drunkenness contributes to careless driving, where the other people become their prey. The poor feel that their lives are not safe. The pedestrians think of uncertainty, and the civilized persons drive in a constant fear, but still apprehensive about the obnoxious attitude of the people who project themselves as larger than life. In such obtaining the circumstances, we are bound to observe that lawmakers should scrutinize, relook, and revisit the sentencing policy in Section 304A, Penal Code 1860. We say so with immense anguish. So in this case, Your Lordship, this 304, very minimum sentence was imposed. Yet,
We
The
have
Supreme
understood
Court
it,
had-
but then you see here the court was concerned about the
Sentencing,
sentence.
not
So
about
this
quashing.
the pronouncement of the apex court highlights
and the
impact.
people, those who suffer, become victim of accidents.
Victim, Your Lordship.
But then here the basically the family of the victim is before
Has
with him.
so your Lordship may kindly
Only thing is that what basically
the
comes
pronouncement.
to see
May I just
whether
conclude?
there
Your
must be something that whether there can be a compromise made on behalf of dead man.
when
Now,
the
that is what is to be said.
that has to be
Now
examined, Your
something.
Lordship.
You can, if you
Here,
can
Your
find it.
Lordship, may I just read the para 10, Your Lordship?
Yes, please.
These pronouncements of the apex court highlights the impact that an offence under section 304A of the IPC has on the society. The guidelines issued by Constitutional Bench of the apex court in Gyan Singh versus State of Punjab 2012 as followed in Narinder Singh versus State of Punjab 2014 cannot be applied in a case of instant nature
Just tell us one thing.
as a
Can we-
crime
can we
committed
go
by
by-
the accused
Can we go by this proposition by ignoring the judgment passed by our High Court?
by a coordinate bench.
That is a difficult.
As held by the apex court in Guru Basavarai, the offence under section 304A of the IPC has the potentiality of making victims in many a layer and thus to create a concavity in the social fabric. It has its own impact on the society, and the impact is felt more when accidents take place, quite often because of rash driving by drunken, negligent, or adventurous drivers who have no concern for the others. The High Court, in exercise of the powers under Section 482 of the Code, cannot send a signal to the wrongdoer concerned that payment of money will be a substitute to the crime committed against the society. Taking a lenient view of an offence under Section 304A of the IPC will leave a wrong impression about the criminal justice system and will encourage further criminal acts which will endanger the peaceful coexistence and welfare of the society at large. Such offences cannot be treated as a private dispute between the parties so as to persuade this court to accept a compromise and to quash the proceedings. The inherent powers under 482 of the Code, though unrestricted and undefined, should not be capriciously or arbitrarily excised, but should be excised in appropriate cases to do the real and substantial justice for the administration of which alone the courts exist. The same has to be excised sparingly, carefully, and with great caution. No such circumstances exist in the case of him. Because a person's life has been lost, precious life. Now, that person himself has not entered into any compromise. It's the parents.
There is some decision which speaks about settlement made on behalf
By
of
somebody else, on behalf of the
and how much
victim.
right even the parents, as you see, of the deceased will have. Some decision is there.
And so when we come to 304, I've done some research, but there was no Supreme Court judgment. But Delhi High Court, there's one judgment, similar facts and circumstances, whether 304A can be said is a crime against the society or whether it's a private wrong. Lordship, Delhi High Court has quashed the entire proceeding, stating that 304A does not impact the society, but it's only a private offence affecting one person itself. There's a judgment by the Delhi High Court, Your Lordship, 2023, if I'm not mistaken.
Until unless you can give anything else,
So
we
let
have
me
to,
examine.
We have to go by the single bench of this court. We cannot.
Because I feel that since the victim himself is not a
And
party
in
to the
absence
compromise.
of any other proposition of law, we cannot refer it to also to division bench.
And interestingly, in both these cases, Your Lordship, if the state had raised similar objections, it would have been understood. But state here had not raised any objections.
You are correct. You are correct. Because
Yes,
these
that is
decisions
all.
are never challenged.
Never challenged, Your Lordship. State shall say it's
And
okay.
it has attained finality.
Yes.
Hard. The problem is that you see, Mr. Pasa, you are a professional, you will be definitely thinking about relief. But then for a court, this kind of orders create a precedence.
Yes.
Now you are binding this court. Even this court is not willing,
Yes,
but then
probably.
because of these orders, court will have to pass orders.
So similar cases will come and be quashed. Your
State is
Lordship.
responsible for that because these kind of orders are not
State should have taken more
challenged.
caution.
See, state is least bothered about consequences. Not only in these things, even POXO matter also. One matter, this court had disagreed with the coordinated bench and matter was referred to division bench. Here, there also, state has never challenged the view taken.
Yes, sir.
That is what the problem. The problem remains there, and it is your duty to advise. You see, you must take into consideration what will have, see what kind of proposition of law will have a bearing on the society. So if there is no one is interested about that, if it only becomes coming to profession doing my case in hand law, then things will go like this. We'll pass a short order by taking this thing, record this order. Heard, Mr. A.R. Pasal,
My
Council.
submission may also be. My submission may also be.
No, you will say we'll record your submission, but then the thing is that
Your Lordship may come to your own conclusion, though.
court has to come to its own
No,
conclusion.
because yes, what I meant was that at least I have opposed, Your Lordship. I'm not that I have read.
Heard, Mr. A.R. Pasal, Council appearing for the petitioner. And MS T. Yangi, learned additional AG, appearing with Mr. So-and-so. And also Mr. Kharkrang, learned counsel, appearing for the
2, 3 and 4.
Kharkrang, Mr. Kharkrang. I'm very poor at remembering names. This is a difficult situation. And nowadays, so many young faces. Stop.
I have the same problem,
Yes.
Your Lordship.
What is application? Under 482. This application. What is application? The petitioner has sought for quashing of the proceeding of the GR case number 31A of 2020 under section 279, 304A and 427 of the Indian. What is 427?
Mischief to the amount of rupees 50.
Minor offence, compoundable.
Minor.
And 427 of the Indian Penal Code. 427 IPC, pending trial before the court of the Judicial Magistrate First Class, Iskasil District, Shillong, on the basis of a compromise dated on the basis of a compromise stroke settlement. What is that compromise?
The compromise is dated.
Page 42, 41, yes.
41.
Dated 6 February 2024, isn't it?
Yes, Your
Yes,
Lordship.
6/2024.
Between the respondent number 3 and the petitioner. You can sit down, madam. Just sit down. Stop. Your paragraph. The fact of the case is that on 6 September 2019, who is the author of this complaint? The respondent number 3.
Number 2.
Respondent number 2. You are respondent number 2.
Yes, Lordship.
So you are appealing for the respondent number 2.
Yes, Lordship. This is the pillion rider.
Okay, so that compromise is between the petitioner and the respondent number 2.
Respondent number 2, respondent number 3 and 4 as well, Lordship.
3 parties, Your Lordship.
Pillion rider was the one.
Just a minute, before pressing the order, just let us. State is only one, isn't it?
Yes, Your Lordship.
And 2, 3, and 4.
Yes, Lordship. 3 and 4 are the parents of the victim.
And 2 is the complainant.
3 and 4 parents.
Yes, Lordship.
And 2 is
the complainant.
He's the complainant.
How complainant is related to the
Because
disease?
the vehicle which had collided belongs to the respondent number 2.
2 is the complainant. That's right. Okay. This agreement is between
respondent number 2, 3 and 4 with the accused person.
So respondent 2, 3, 4 on the one part
And
others. You are on the other part. Yes. What do you say on the basis of a compromise entered into between the no before that what do you say on the basis of a compromise? No, between the petitioner and the respondent number 2, 3 and 4. Between the petitioner on the one side and the respondent number 2, 3 and 4 on the other side. Stop. Then you come. That paragraph, then is the effect of the case is that on 6/9/2019, the petitioner, along with late Kaban Star shooting, were traveling on a motorcycle bearing registration number ML05J 8318, proceeding from Lightcore Sevillat, Lightcore, then separate KSEHBILAT to Ladnongram. Stop. However, on reaching Lightcore Mawarling, MAWWARLING, his motorcycle met with an accident.
Nine 2019.
9/9/2019. Stop. In order to avoid any legal complicacy in the matter, there's one number 2 filed an FIR dated 9/9/2019 reporting the incident to the officer in charge, Modern Road Police Station. Stop. On the basis of the FIR, Modern Road PS case number 97 within bracket 9/2019 under section 279, 337, 338, 427, 304A IPC read with section 182 of the MB Act 1988 was registered. Stop. Upon completion of the investigation, the matter was charge sheeted by charge sheet number 19 of 2020, which is pending trial before the Court of the Magistrate First Class, Shillong. Being GR case number 31 within A 2020. During the pendency of the case, the petitioner and the respondent number 2, 3 and 4 have respondent number the 2, 3 just a minute. What is it? The petitioner and the respondent number 2, 3 and 4. 2, 3 and 4. Do not say 2, 2, 4. 2, 3 and 4. Who are the complainant and the parents of the deceased victim. Have amicably settled the matter by a deed of compromise dated 6/2/2024. Stop. It is a case of the petitioner that since section 279 and 304A IPC are non-compoundable offences, yes. Do not say section so and so IPC involve non-compoundable offences. Do not say are involve non-compoundable offences, comma. The petitioner has approached this court seeking quashing of the procedure on the basis of the said compromise dated 6/2/2024. Stop. Paragraph. Mr. Pasa, learned counsel appearing for the petitioner, submits that the offences involved in the matter are private in nature, having no bearing with the affairs of law and order of the state. And no public involvement, no public element is involved in the matter. The learned counsel submits that the taking place of the accident was an unfortunate event without any fault or intention of the parties involved, and hence for the ends of justice the criminal proceeding initiated needs to be closed. Learned Counsel contends that the parties involved have settled the matter. No useful purpose will be served by allowing the proceeding of the criminal case to continue before the trial court. And praise for quashing of the scene. Stop. In support of his argument, the learned counsel has placed reliance on the judgment these are what, orders or judgment or what? Nothing is written. Will be judgment on two different orders passed in two different orders. Asha has placed reliance on order dated 16/3/2021 passed in criminal petition number 11 of 2021. Then you write party's name, okay, and order dated 1/10/2021 passed in criminal petition number 34 of 2021. Then you keep space for parties, wherein in similar situation wherein in the similar facts and circumstances this court had allowed this high court has allowed the High Court has quashed, you just say, has quashed criminal cases pending trial on the basis of compromise attained by the parties involved therein. Stop. Next paragraph. MST Young Learned Additional Lechi, par contra submitted that the submitted that as a result of the accident, one innocent young person has lost his life. Stop. Lost his life, and there cannot be a compromise. in such matter. Stop. Give a stop. She further submits that offence under section 304A has its own impact on the society. And cannot be compromised by the parties on the pretext of a private offence, treated of a offence which is purely private in nature. Raja submits that accidents resulting in loss of life has become a regular event because of rushed driving by drunken, negligent and adventurous drivers who have no concern for others. Stop. By placing reliance on a judgment reported in 2016 SCC Kerala 4258. You see this from there. We just record the names. Just give us an answer. Yep. The learned AG has submitted that this kind of offence cannot be compromised, and in that view of the matter, this quashing application cannot be entertained. Stop. Mr. Kharkang, Learned Counsel appearing for the. You are representing 2, 3, and 4. Yes. 2 and 4. Supports the contention. Supports the application. Supports the application and acknowledges that a compromise has indeed been arrived into by the petitioner and the respondent number 2, 3, and 4. He submits that the complainant and the parents of the victim have voluntarily decided not to pursue the matter anymore, as the same would not serve any purpose they would not serve any meaningful purpose for them. Stuck. Give a paragraph. The submissions made by the land councils have been given due consideration by this court. Give a paragraph. The perusal of the materials on record reveal that pursuant to the occurrence, pursuant to the accident which took place on 6/9/2029, comma, on the basis of the FIA lost by the Resolution number 2, comma, the moderating PS case number 97 within bracket 9 of 2019 was registered and subsequently charge sheeted and forwarded for trial. It is apparent that during the pendency of the trial, the parties involved, that is, give i.e. the petitioner and the respondent number 2, 3 and 4, have compromised the matter voluntarily out of their own will. What you said just last minute? And decided not to pursue the criminal case pending before the trial court. It was also agreed by the parties that they will support the petitioner to get the criminal case pending, but get the criminal case quashed by the High Court. there appears to be no doubt insofar as the settlement of the matter is concerned. Stop. Though the learned AG has taken a strong objection to the prayer for quashing of the petition by placing reliance on the judgment of so and so supra of the Karnataka High Court, no? Of the Kerala High Court, comma, the objection the same cannot be entertained in view of the passing of the order dated 1/10/2021 and 1/10/2021 in CRP number so and so and 16/3/21. So first you write 16/3/21 and then you say 1/10/21. Okay. In criminal nomination number so and so by this High Court, by a coordinate bench of this High Court, in the similar and identical matter, involving similar and identical matter. If I miss something, just correct it, grammatical. It's the perusal of the aforesaid order of this High Court would show that same year passed by placing reliance on various judgment of the apex court. Since since the decision of coordinate bench is binding on binding on subsequent bench, comma, the judgment dated 16/3/2021 and 1/10/2021 are binding on this court. Give a paragraph. Yes, there exists no dispute between the parties that the facts and situation involved in the present case is similar and identical to the facts and situation involved in criminal petition number 11 of 2021 and 34 of 2021. Comma. This court finds is appropriate. To allow the prayer made by the petitioner in this criminal petition. Stop. Resultantly, the further proceeding of what is that case?
GR 31A.
GR case
31A.
number 31 within bracket A of 2020 under section 2017-1, comma 304 within bracket A and 427 IPC pending before the learned court of the judicial magistrate first class, East Khasi Hills district, Shillong, stands quashed. There is no other option. He has snatched the order. This court was not very much inclined to grant it.
I understand, Your Lordship.
But then, so long this order prevails, you allow it to remain, the court will have no other.
Yeah.
Because the apex court says that the judgment of coordinate bench is binding on subsequent bench. So that is the law.
And Your Lordship's query with regards to whether a settlement can be agreed on behalf of a deceased person. So I've just found out section 2WA of CRPC states the definition of victims. Victim also includes the legal heirs, Your Lordship. And
there is no dispute, you see. Victim definitely includes, so far as the definition is concerned. But then, victim in that case stands at a different footing.
Yes.
Whether they can enter into a contract.
That is where there is some law. Yes. Probably you will find it out. Of course, it will not be helpful for cases of this nature for
just
you. But then for your own knowledge or for our thing, you can always look for it. It would help us, if not in this litigation, some other litigations.
Yes.
There may be a bit correction here, there, if because in the dictation there remains sometimes. Nothing more.
Obliged.